Iddat case. Islamabad court rejects IMRAN. Bushra's pleas seeking suspension of sentence. An Islamabad court on Thursday rejected an application filed by former Prime Minister and Pakistan Tehreek-E-Insaf founder Imran Khan and his wife Bushra Bibi to suspend their sentencing in the Nikkah during the Iddat case. In a 10-page verdict announced in Islamabad District West Court by Additional Sessions Judge Muhammad Afzal Majoka on Thursday, the court noted that no grounds for suspension of sentence is available to both the petitioners. The court then dismissed their application. Imran and Bushra Bibi had moved the district court to challenge their February 3, 2024 conviction, in which they were sentenced to 7 years imprisonment by an Islamabad magistrate for failing to observe the minimum period between divorce/dissolution of marriage and a Nikkah. The court had on Tuesday reserved its verdict, with a hearing on the core petition connected to the annulment of their convictions scheduled for July 2. Bushra's former husband, Nikkah, had petitioned the court to annul the couple's marriage. In its order, Additional Sessions Judge Majoka noted that Bushra Bibi's lawyer, Barrister Salman Safdar, contended that since his client was convicted under Section 200 of the Criminal Procedure Code, COC, only bail bonds are to be submitted. He further argued that since appeals are a continuation of trials, only bail bonds need to be submitted under Section 91 of COC. Both the petitioners did not commit any fraud and dishonesty with anyone, the lawyer contended, adding that a fair trial was not provided to the petitioners, which offends the provision of Article 10 of the Constitution. Moreover, the lawyer argued that Bushra Bibi was entitled to bail because she is a woman, a precedent for which was recognized in the Tahira Batul and Ernst Ghazala cases. However, the court noted that bail is considered when the petitioner is an accused but not when they have been convicted of the crime. A person convicted of such an offense would not be entitled to bail under Section 426 COP, unless strong grounds are made to appear that conviction is not liable to be sustained, the court observed. Further, the court noted, suffice it to say, that like the first proviso to subsection 1 of Section 497 COP, there is no such provision in Section 426 COC. Although no ground has been taken in petitions under Section 426 COC, and during arguments that the petitioners convicted for an offense under Section 496 COP is bailable one, and petitioners are entitled to bail as a matter of right. Yet this court has considered this aspect of the matter as well. Admittedly, petitioners have been convicted for an offense under Section 496 COP, which is bailable, it said, adding that grant of bail to a convict in bailable offenses shall be an indefeasible and inalienable right, like an under-trial person is entitled to, under Section 496 COC. However, the court added that there could be no such general rule that a person convicted of a bailable offense is entitled to a right to be enlarged on bail during the pendency of his appeal against his conviction. In reaction to the lower court's judgment, Secretary General Omar Ayub Khan stated, "We will challenge the verdict in the High Court immediately." The PT strongly condemned the ruling, calling it absolutely ridiculous, and its leaders, who were hoping for Imran's release today, held a demonstration outside the Adiala jail, where the court was set up to safeguard the ex-Prime Minister's safety.